Mexico has been at the forefront of this movement in Latin America, establishing a robust legal structure with the enactment of the federal law on the protection of personal data held by private parties in 2010. This groundbreaking legislation, along with subsequent regulations and guidelines, showcases Mexico's commitment to safeguarding personal data within its borders. A comprehensive framework. Mexico's privacy laws are comprehensive, applying to the processing of personal data by private entities or individuals. Notably, these laws distinguish between data handling by the government and by private parties. The cornerstone of this legislative framework is the law, accompanied by various regulations and guidelines aimed at ensuring thorough data protection. These include privacy notice guidelines, recommendations on personal data security, and parameters for self-regulation. Scope and application. The reach of Mexico's privacy laws is extensive, encompassing any personal data processing within specific contexts, such as processing by data controllers established in Mexico, or processing on behalf of controllers outside Mexico but subject to Mexican legislation. The laws are designed to protect data within Mexican territory, underscoring the country's jurisdiction over its digital landscape. Key authorities. The National Institute of Transparency, Access to Information and Protection of Personal Data, INAI, and the Ministry of Economy serve as the primary authorities overseeing data protection in Mexico. Their roles are crucial in enforcing the laws and ensuring compliance among data controllers and processors. Data protection and privacy notices. Under Mexico's privacy laws, personal data is defined broadly, encompassing any information related to identified or identifiable individuals. The law places a particular emphasis on sensitive personal data, demanding stringent protection measures. Data controllers are required to adhere to principles like legality, consent, and transparency, ensuring that data subjects are fully informed through privacy notices before their data is processed. The rights of data subjects. A cornerstone of Mexico's privacy legislation is the empowerment of individuals regarding their personal data. The laws grant data subjects ARCO rights, allowing them to access, rectify, cancel, or oppose the processing of their data. These rights are fundamental in enabling individuals to maintain control over their personal information. Data transfers and security. The transfer of personal data to third parties is subject to specific conditions under Mexico's laws, often requiring the consent of the data subject. Data controllers are mandated to implement security measures to protect personal data from unauthorized access. In the event of a security breach, controllers must notify the affected individuals, ensuring transparency and accountability. Enforcement and penalties. INAI is vested with the authority to impose sanctions for violations of the law, ranging from monetary penalties to imprisonment in severe cases. This enforcement mechanism is vital in upholding the integrity of Mexico's data protection efforts. Introduction. Under Mexico's federal law on the protection of personal data held by private parties, hereafter referred to as the law, data controllers are saddled with various obligations to ensure the protection and respectful handling of personal data. Among these responsibilities, the notification obligation stands out as a crucial mechanism designed to uphold transparency and foster trust between data subjects and controllers. Breach notification obligations in Mexico. Under Mexico's privacy laws, particularly the federal law on the protection of personal data held by private parties, data controllers are mandated to notify the National Institute of Transparency, Access to Information and Protection of Personal Data, INAI, and the affected data subjects in the event of security incidents that significantly impact the rights of the data subjects. This obligation is pivotal in ensuring transparency and accountability, allowing individuals to take appropriate measures to mitigate potential damages. The notification to INAI must include a detailed description of the breach, the personal data involved, the potential consequences, and the measures taken or proposed to address the breach. Furthermore, it should outline steps to prevent future incidents. When notifying data subjects, the communication must be clear and concise, providing all necessary information without causing undue alarm. Conclusion. Mexico's privacy laws represent a significant stride towards the protection of personal data in the digital era. By establishing a comprehensive legal framework, emphasizing the principles of consent, transparency, and security, Mexico has positioned itself as a leader in data protection in Latin America. As digitalization continues to permeate every aspect of society, the importance of such legislation cannot be overstated, serving as a model for other nations aiming to safeguard the privacy of their citizens.